Good afternoon. Welcome on in to another episode of From Day One. This afternoon we have a subset who really has a weird look in the world of physics. Along for the ride, of course, will be my criminal talk with Michael. He loves stuff like this.
We're in control.
Well, there you have it. That was fun.
Mike, you
I
haven't started.
he added some good stuff.
Mike, you haven't started. So try again, Mike.
Wimbishi?
Kapuma.
Here we go.
No, your last name.
I am Kapuma.
Okay, what's your last name? Wimbishi?
Kapuma is my last name.
Okay, so what's the first one then?
Mwembeshi.
Okay, there you go. They have it reversed. Thank you. Okay.
Yes.
Yeah, okay.
Oh, they
So-
have it reversed? Okay.
So it's Wimbishi Kampuma.
So your name is, like, your last name is Kapuma then?
My last name is Kapuma.
Okay, we'll make sure didn't want to destroy it, too bad with my accent.
You will.
So I guess they need to know that because they have it reversed.
Yes, and because of that, it's an invalid contract.
No,
Well,
no, it's
Because
not.
not necessarily, that's just a typo, but.
yeah, but according to this,
We're just kind of getting started here, okay? So I'm just trying to pronounce your name right. That's basically all that is, okay? All right, so this is number 122 CP 214772. Here it's Kapuma Wimbishi, but it's actually Wimbishi Kapuma. So I think they could probably modify that at the jail. I guess y'all want to take care of that. Okay, so we got
Trial.
Okay, we're behind. We've got a soft sit in front of Judge Manning. I don't know what happens.
285 days without indictment. He had a Ferretta hearing and he's representing himself. So it's aggravated battery, willful obstruction of a law enforcement officer with a felony. Officer, if you could raise your right hand for me. You swear affirm testimony you're about to give is the truth, whole truth, nothing but the truth.
Yes, ma'am.
All right. If you state and spell your name into the microphone for the court reporter, please.
Yes, ma'am. My name is Patrick Marsh. First name is spelled Patrick. Last name is spelled Marsh, Marsch.
Oh, sorry, not pre-trial. We're actually going to
Okay,
trial.
Officer Morse.
Okay, so 1 second. So, sir, what this is a preliminary hearing, okay?
Oh,
It's
okay.
just to establish that there's probable cause. So the DA is going to ask some questions and then you get to
Post-trial.
ask follow-up questions, okay? All right? So go ahead, Ms. Fields. And this is Ms. Kelly Fields. She's one of the assistant district attorneys. Go ahead, Ms. Fields.
Thank you, Judge. Officer Morse, can you tell us, you already told us your name, but can you tell us where you work and what your title is?
Sure. I work for the City of Atlanta Police Department and my title is rank as an officer.
Okay, and are you post-certified?
Yes, ma'am, I am.
Were you post-certified on the date in question? On December the 15th of last year?
Yes, ma'am, I was.
And can you tell us what happened on that day?
Sure.
Regarding Mr. Kapuma?
Sure. So on that day, I was dispatched to a call at 1776 Peachtree Street. There was a fight going on that apparently was going on the fourth floor at the clubhouse. We had received several calls as well, arriving on scene from a passerby saying that there might be a weapon involved. So I immediately called for backup. Officer Jones and Officer Easton arrived on scene to assist me. We go up to the fourth floor. We go to the right where the clubhouse was, and we found a white male victim named Keith Johnson that had a gash to his forehead. We had asked him what had happened, and he said that he had been knocked out by the defendant.
When you say knocked out, can you tell us what that means?
Sure. So apparently the defendant said that they had noticed.
Sure, that means actually
the victim had
knocked
noticed the
the
defendant
fuck out.
acting in a strange manner. And when he went to put his hand on his shoulder to ask if everything was okay, he advised that the defendant hit his upper right eye with a closed fist, causing him to go to the floor and was unconscious
Okay.
during that time.
So he was unconscious?
He was unconscious, but he was not unconscious when we arrived on scene. But
You were gaining consciousness?
yes, ma'am.
Okay, now you said that this happened at what address?
1776 Peachtree Street.
Is that in Fulton County?
Yes, ma'am, it is.
And can you identify the defendant and describe what he's wearing and where he is in relation to you?
You
Oh,
can
that
stand
should
if
be
you need
easy.
to.
Oh, I can see it on the screen here, ma'am.
Yeah, that's okay.
Thank you very much. Yes, I can see the defendant. He is wearing a blue Fulton County uniform with a white shirt under it.
Okay. Let the record reflect that the witness has correctly identified the defendant.
All right, noted.
So we talked about that that Mr. Kapuma rendered this man, Mr. Hugh, unconscious. And is that the basis of the aggravated battery?
Yes, ma'am. So under the code section of 16524, the elements of the crime of aggravated battery indicate that you render a limb unconscious. And so with the brain being a member of the body, we decided to go ahead and move forward with the aggravated battery because the brain was rendered useless during that time.
During the time that you was unconscious?
Yes, ma'am.
Okay, and did EMS arrive?
I'm sorry?
Did EMS arrive?
Yes, ma'am. Mhm.
And what happened with that?
I'm sorry?
What
What
happened with,
happened
excuse
with
me,
that?
I'm talking
Okay,
about,
all right.
what happened with that?
So during the incident of while we were trying to get the defendant into custody, he was resisting myself and numerous
Big
officers.
surprise.
So one of the officers on scene had to deploy a City of Atlanta issued taser in order to try and get him
Oh, I
into
want that
custody.
video, Mikey.
And during that time, that's why we called EMS to go ahead and have them remove the prongs as well as go ahead and check his vitals because he did appear to be acting in some type of irregulated manner, whether it could be on, just having a mental breakdown or something of some nature, but he
Mikey, I
clearly
want that
needed some
video.
medical attention, which is why we go ahead and call EMS as well.
Was EMS called for Mr. Hugh?
Yes.
Okay, did he allow them to treat him?
He did not need EMS. When we got there, we asked him, he said that he did not need it. Some of the witnesses and the friends who were at the event were tending to the victim.
Now, with the charge of willful obstruction, was there any violence or offering of violence or
There-
just resistance?
There was no offering of violence. There was just actively resisting when giving verbal commands.
Okay. Um, and you said that Mr. Hugh Johnson was concerned about how Mr. Kapuma was acting.
Yes. So
Can you describe how he was acting and what you were told?
yes. So what I
dick.
was told by the victim is that at some point this was a company event that was going on, and during the course of the event, at some point, the defendant had put, according to Mr. Johnson, had put his AirPods into his ears, and he started being very incoherent, saying a whole bunch of stuff that Mr. Johnson didn't understand. And according to him and several other people at this event, they had never seen the
Nobody
defendant
had ever
act
understand
in this manner before. And
Mhm.
so when Mr. Johnson put his hand on the defendant's shoulder, that's when the defendant acted out.
That's when the altercation happened.
Yes, ma'am.
Yes, ma'am. That's when the idiot ducked him.
Okay. Do you have any other statements you'd like to make to the court regarding these two charges pertinent to this case?
Yeah,
That's in this case, no.
now, see, if
Okay.
you actually had a good attorney, they could
That's all I
object to
have
that.
for right now. It's your witness, Mr. Kapuma.
All right, Mr. Kapuma.
Okay, thank you, Your Honor.
We need the fly lawyer now.
I have a question, right? Because according to this warrant, first of all, it shows here that he was called for a fight.
Okay, stand by. What questions do you have for the officer?
Yeah,
Yes,
question.
that's who I'm asking. Because I can't see him, so
Oh, okay.
You can't see him on your,
okay, so he was called in for a fight, right? So according to this statement, Keith Johnson put his hand first on me. Then I reacted to that with a punch. It doesn't show how hard he pushed my shoulder. It was in a hostile situation because I was at a party.
Okay, so stand by.
Thank
What
you,
is
Your
your
Honor.
question?
So
Who, what, where, why, when?
so
how?
in that situation, who was the aggressor in that situation?
You.
Because he put his hands
Hold on.
first on me.
Just ask a question.
Mhm.
You. Next
So-
question.
Okay, so based on when we spoke to the witness, I had the witness actually show me how he placed his hand on the defendant. And Mr. Johnson said he basically just placed his hand in a almost caring way, just a concerning way on his shoulder to see if everything was okay. And that's when the defendant acted out and hit the victim.
Okay, next question.
So is there a written signed statement from the witness about that incident to describe what you're saying so that they sworn like a sworn,
Hold on.
a sworn
No,
affidavit?
you asked the
What,
question.
where,
Shush.
why,
I'm
when?
gonna have to object. Compound question. Can we?
All right. So
Um,
you ask a question like this. Do you have a written statement from the victim?
Do I have written a statement? No. Do I have it on body camera? Yes.
Okay, next question.
So how'd that work out for you?
Yeah,
So
next question.
there's body camera for the entire event from all 5 officers of what happened.
Yes,
Yes.
so my body camera was activated from the time I arrived into the parking deck before I made contact with anybody up until the very end
Mikey,
of the incident as well. So there is
doesn't
a
the
full
city
body camera
know
footage
about,
from
you
start to
know,
finish, including
discovery?
a body camera footage from each of the officers during the interaction as well.
Okay, so from my recollection, right?
Whoa.
Oh,
no.
fuck.
If you want to say something, you have to ask him a question. So she asked him
Hmm,
questions, so you ask follow-up
question.
questions to what she asked.
Question,
Okay,
not statements.
so based on the
Question.
body cam video that you're saying,
All right, let's see
does
if we
it
can do
show that I was tased
Ask.
until I passed out or died and then had to be resuscitated?
Or died?
So the
What?
body camera footage
Yeah,
from
Mikey,
Mr.
I want that
Jones,
video.
I would appear, because Mr. Jones is the one who tased the defendant, but the defendant at no point in time lost any consciousness or at any point in time had to be resuscitated by Grady.
Okay. Next question.
Oh, I want to see the tasing.
Me too. I
S-
told you, I want
So this, I understand. So when will I be able to see the body cam? Because I haven't had a chance to look at it, see what exactly happened on that
Not
event.
a question for
All
the
of that gets
officer.
turned over at discovery, but allegedly you were there. So what's your next question for
Yeah.
him?
If you had the fly attorney, you would have been able to see this by now. Just saying.
According to the law, which
Okay.
I'm new to,
Yeah.
did I
no
give
kidding.
consent to be arrested? Because according to the,
Mikey, did he just say that he
Judge,
gave
counsel-
consent?
well, I don't know if I should call him counsel, but
That's actually,
he's been testifying, and so we object to testify.
so
I'm sustained.
did you give consent to be arrested? Did he give you his consent to be arrested?
Your Honor, he did not consent to get arrested, but based on the elements of the crime, we had enough probable cause to make the arrest.
Good answer.
Next question.
um,
Oh, that was fun. Pretending that question wasn't insane. The judge actually enjoyed it herself.
was
Good
based
answer.
on my understanding.
No,
You're understanding
question.
it. You're understanding.
if you
in a
want to say something
quarter
later, you can.
is worth a
But
quarter.
what's your next question for him?
Okay, so in terms of the resisting arrest,
Okay. So far, so
is
good.
it not my right not to resist if there's no jurisdiction over me?
No. But go ahead, Your Honor.
Stand up.
No, I told him to stand by. I didn't know if you had an
Oh.
objection.
Objection calls for legal conclusion. It's compound and there's double negative.
Thank
It's
you.
also not relevant.
Yes, I have a judge, I understand when you're giving him leeway, and I understand the reason for that. However, counsel has been not asking direct questions on cross.
The reason for that is he's a big dummy. The prosecutor's being cool here. Like I understand he's a simpleton, and I don't want to object to everything, but you know this
Your Honor,
this
yeah,
is out
enough's
there.
enough.
And he has been testifying numerous times, so we just have an overall objection to that testifying that's been happening from pretty much from the start of this questioning. So we ask that he ask direct questions, not have this kind of commentary in addition to his questions.
So what you're asking is him to draw a legal conclusion. So
Yes.
what's your next question?
Go for
What's
it,
your next
Major.
question for him?
Oh,
Because for me, it's mainly about consent and jurisdiction.
Hey, hold on.
Oh.
That's argument.
Argument.
But what question do you have for him?
I don't have any questions for him.
All
Good.
right,
Okay.
anything else
That's
for
what
the
we
officer?
thought.
I do have some redirect.
Okay, go ahead.
So, officer, I know I was calling this the victim Hugh. That was my mistake. I meant to say the correct, but the correct victim's name was Keith Johnson. Is that correct?
Yes, ma'am.
And Mr. Johnson was hit by Mr. Kapuma.
Yes, ma'am.
Okay, and that's all I have.
Thank you, ma'am.
All right. Any follow-up based on those questions that she asked?
Basically,
No,
Not
basically.
Okay,
Okay,
thank you,
good.
officer. Stay
Smart
safe
man.
out there.
Thank you very much. You know, you
Have
stay
a
safe
good
as
day.
well.
All right, go ahead with the argument. Let's hear from the state.
So Judge, I believe that we have met our burdens for our probable cause
Yeah.
Basically, not really. Merch shirts coming soon.
for the first charge, which is aggravated battery.
Which is
the,
aggravated stupidity.
defendant did render Mr. Keith Johnson's brain useless by, rendering him unconscious for a period of time where he did, fortunately regain consciousness, but he was rendered unconscious for a little while after he was struck by Mr. Kapuma. And as far as the wolf obstruction, we understand there was no violence or offering of violence against, the officers and Mr. Marsh and other officers at the party. So we suggest that should be a misdemeanor and not a felony. But other than that, we think there's probable cause for both charges as just stated by myself and the state.
All right. Do you want to respond? Now, this is where you give argument. So now is your chance to give argument.
Now's your big
Okay,
chance.
so first of all, based on just this warrant, my name is spelled in capital letters. It's in reverse. From my understanding of law, that's the name of a
Contentious.
straw man or a corporation.
No.
So that does not apply to me
Yes, it
because it
does.
says the accused is capitalized. That's a corporation, and the straw man, which has no bearing to me. And in this matter, I do not give consent or agree to represent
Lord.
my straw man in this case.
Who's got
'cause
bingo?
I'm a sovereign being. I'm an
You're a moron.
internationally protected person. But at the
He's a
same time,
protected moron.
from my understanding of the constitutional law, which is the law of the land, I have to give informed consent or sign a contract in order to be judged or in order for the case to move forward in this
No.
regard.
No.
So your
Because
understanding is
according
wrong.
to the Fifth
Yes.
Amendment, one of the things is before I can be arrested or detained, I
Wrong.
have to be indicted. I have not been indicted. One,
Why is this
I
guy a
did not
stupid
give
person?
consent to be arrested or to be tried under this jurisdiction because I operate under common law.
No, you
That's
operate
my
under
jurisdiction,
stupidity.
common law, God's law, and natural law. I do not consent to be tried by the Admiralty law system, which is evident by the God fringe on the flag and the eagle at the top, which shows this is the maritime law, which is commercial law. And as a sovereign being, I report to God. God is my judge.
No,
As it relates to how I
God
interact
said,
with other humans,
I'll take a day off.
it's only by common law, which is when I injure a human being, and that's also dealt with in the common law court. And
Something
based
with you
on
being
my
stupid.
international status, because I am a king where I come from, an internationally protected person.
You are
So according to
not a king.
Executive Order 143107, which is human rights, this is a violation of human rights. From my understanding of the law and my rights, my
You don't have any
unalienable rights,
understanding.
if I have not given consent to be tried or to be held or to be detained by or given jurisdiction authority to the officer, and they arrest me, that's a kidnapping, and I'm being held hostage right now. Because according to the Constitution, I have to be indicted before I can be detained.
No,
That's according to the Fifth Amendment rights.
no, it
And
ain't.
the Constitution, from what I understand, is still the law of the land. Because according to the Supremacy Clause, every case, if I can cite one case, which is the Madison versus Marbury, every case in that situation
Mikey.
decided that case as
Yes.
into the legality of the
To
constitutional
say, I'm not an
unconstitutionality
attorney, and even I
of
know
any
that one.
situation was overturned by the Supreme Court. So in this situation, yes, I did react to Keith Johnson putting his hands on me. Though the witness may have said something, they might have been friends with Keith Johnson. I
Do we
reacted
actually
to
have
a
a question
situation.
coming?
For every action, there's an opposite and equal reaction. He touched me first.
Oh my God, this is fantastic. So what we have here is, yeah, I hit him, but Marbury versus Madison and the law of thermodynamics.
Yes, Mikey.
or something. Oh, this is fantastic.
I reacted. When the officers came to arrest me, I didn't do anything wrong but defend myself.
Yes, you
I've
do.
been charged with willful obstruction. according to the Constitution, according to my unalienable rights, according to my human rights, I've got the right to
Unalienable?
defend myself. If I put up on anyone over here and just touched you on your shoulder without even asking for your consent, some people would tase me. The officer will shoot me. But if the same thing happens to me, he touched me first. I reacted off
I
of that.
don't
That's
care.
self-defense.
No. Somebody going,
Anything
are
else?
you okay? It's not self-defense.
All right, so I'll find probable cause on
Yeah, so do I.
the aggravated battery, and then the misdemeanor, the willful obstruction will be reduced to a misdemeanor.
Oh,
And we'll go ahead and address bond. Let's see.
None.
Right now.
Fair enough, Tater Todd. This performance is officially two hat stupid.
yes.
Bond. Let's see. Right now, as of June 27th, there is a $30,000 good bond.
Good bones.
Bond.
Thank you. I was waiting for that.
The defendant has 3 cycles. The defendant's last arrest was May the 9th, 2021 in Dunwoody, Georgia, for terroristic threats act and possession of a firearm during commission of a felony and criminal attempt to commit a felony. There was no disposition for that arrest, and there are no convictions listed in the GCIC. Nothing in addition, Your Honor.
All right. Go ahead with your bond argument, sir.
This ought to be
First
good.
of all, it was just a punch.
Oh, yeah.
And I don't see how it can be a felony. And if it was pretty much a misdemeanor at best, because one, it was self-defense, misdemeanor at best, the maximum is 1 year, and I've already done 10
It's a misdemeanor at best. No, it's a felony. They charge it as a felony. We've had a prelim and they've established it. No problem.
months in jail, pretty much, for one punch in self-defense, in
Pretty
defense
much.
of myself. At the same time, I feel like I have already done the time for this.
Oh, you're wrong.
Okay, anything else? All right, what says the state?
Judge, the state is inclined to keep the bond as is because the severity of the injury that took place against Mr. Keith Johnson, he rendered unconscious. The punch that, counsel is trying to minimize was very severe. The punch took him out. So because of that, and then him resisting arrest, we do believe that a $30,000 bond is sufficient.
All right, so it'll be no further contact. Johnson, state.
She's cool. She didn't get upset about any of this stuff and just sat there patiently and then just dropped a bunch of competence on the court, which was nice to see.
Away from 1777 Peachtree Street Northeast. You're gonna have no drugs unless prescribed, no alcohol, no weapons. It's going off my bond order of 627. You have an ankle monitor paid for by the county with a 24-hour curfew, court, lawyer, medical, employment, as long as you supply the name of your employer, proof of employment schedule, and the exact location you'll be working. Are you still gonna live in Roswell, sir?
Sandy Springs.
Sandy Springs, okay. All right, so just supply a good address to the jail upon release. So 15,000 count 1 and count 2 is reduced to misdemeanor, so that'll be 5,000. So $20,000 good bond. Best of luck to you, sir.
I don't think he's smart enough.
We're in control.
Well, there you have it. That was fun.
Yes, Mikey, give us a recap.
He added some good stuff. Where do we have here? I've been trying to get this one on.
Oh, you got some more for us?
We got the equal and opposite reaction nonsense, but he went hard. He went hard with international law.
Yeah, the moron did.
So let's find it. Let's find it. There we go. I need to bring in my good buddy Derek to explain this to everybody.
Received international attention.
International attention.
I'm assuming international attention.
Oh, he was bad. It was subtle too when it was kicked off. I was trying to make coffee, but I really liked, he makes the whole name argument, and he's like, no, they've got my name reversed, and he's got like, which is entirely possible because he's got a foreign name, so it's not common here. So it wouldn't surprise me if they reversed it. But Judge Brandon's like, that'd be more like a typo.
Correct. It is. All right. I'll let you laugh with your folks. I definitely appreciate it. We'll call the afternoon a close here on From Day One. Come on back tonight for more fun, more substance, and more morons as we march along in Dominion here from Day One. Have a great afternoon. We'll see you all tonight.